Good morning, everyone. Welcome to today's forum. I'm Jocelyn Boyd. I'm employed by the Public Service Commission. Let me tell you a little bit about why we're here today. On April the 11th, 2025, the clerk's office issued a notice of public forum, and that notice of public forum was initiated by Commission Order number 2025-181. If you may recall, our Vice Chair, Justin Williams, made the motion, and the commissioners agreed with the terms of that motion, which resulted in Order number 2025-181 being issued. The order basically states, I move the commission direct the chief clerk to schedule a public forum in a non-docket for interested stakeholders to provide feedback and comments related to efficiency, effectiveness, timeliness, fairness, and user-friendliness of the commission's regulatory processes, including but not limited to the following. 1, notice of public hearings. 2, public hearing scheduling, location selection, and time allotted for witness testimony. 3, the value of filing pre-hearing briefs. 4, the value of pre-hearing, post-hearing, and status conferences for planning and scheduling proposed orders. 5, the value of pre-hearing, post-hearing, and status conferences for planning the time frame to issue commission orders that are not governed by statutory deadlines, including suggestions for any particular dockets that necessitate a commission decision within a specific time frame. 6, commission business meeting time and schedule. 7, the commission's docket management system. 8, the commission's allowable ex parte briefing process. 9, the commission's process for selecting consultants and applicable dockets. And 10, the commission's website and meeting live streaming process. So the clerk's office on, as I said earlier, April 11th, issued a notice of public forum, and we provided notice to the public that today's public forum would take place today in the commission's hearing room, today being June 13th, 2025, beginning at 9:30 a.m. All right, and there were several stakeholders who were interested in today's proceeding. I don't call it a proceeding because it sounds too formal. It's a public forum. And we ask that those who are interested in participating in the public forum to notify the commission on or before Friday, May 23rd, 2025. And we thank all of you who did that. And then if you wanted to file written comments, to please do so on or before Friday, May 23rd, 2025. So the next procedure or matter that I had written down for us to complete is that I would ask everyone who's present today to introduce yourself and who you're representing. If you don't mind, I'm going to call the names of everyone in the order that you filed your written documentation in the docket management system. So even if you said, well, I'm going to be present, I'm representing my client, but I don't have any comments at this time. We don't have any comments at this time. If you don't mind, I'm still going to call your name in that order, okay? So the first name would be Attorney Nanette Edwards. Ms. Edwards, would you please identify yourself and who you represent?
Yes, good morning. Nanette Edwards. I'm here on behalf of the South Carolina Telephone Coalition, and I'm with the firm Burr Foreman.
Thank you so much for being here and participating. Mr. Attorney Charlie Turaney, good morning.
Good morning. Charlie Turaney. I'm here on behalf of the Nexus Water Group Utilities.
Thank you for being here and for participating. Mr. Anselmo, you filed the letter on behalf of your client. Would you mind introducing yourself and anyone else who's here?
Sure. Michael Anselmo with McGuire Woods. I'm here on behalf of Dominion Energy, South Carolina.
Thank you. Mr. Mustian?
Thank you. Ben Mustian on behalf of the South Carolina Office of Regulatory Staff. With me today is Lauren Beckman. She's a law clerk with us since I mentioned this to Ms. Boyd earlier, since even though she's not an attorney, since
yes,
this is not a formal proceeding, if there was no objection, was going to have her sit and throw her in the fray if need be.
Yes, sir. Glad to have you, Mr. Mustian and Ms. Beckman. Mr. Wellborn, would you mind introducing your team?
Good morning, Jocelyn. Sam Wellborn on behalf of Duke Energy Carolinas and Duke Energy Progress. I have with me this morning co-counsel Lyle Trawick of the firm Robinson Gray and Ms. Heather Shirley Smith, who is serving as Vice President of Regulatory Affairs and Policy for the companies.
Thank you. Thank you all for being present and participating. I think it's Deputy Consumer Advocate Roger Hall.
Good morning, Jocelyn. Yes, Roger Hall with the Department of Consumer Affairs. Thank you.
Thank you for being here. Attorney Jason Richardson.
Thank you for being here, Jason Richardson, on behalf of Piedmont Natural Gas Company.
Okay. Thank you for being here too. Last but not least, Attorney Witt or Attorney Burns.
You're muted, Richard. I believe Richard's muted.
Hey, Richard.
Are you muted? Well, you can't hear. Well, you can hear me.
I'm so sorry.
Hey, good morning.
Richard Witt for SECEBA. I sent in written correspondence for SECEBA under my name, but General Counsel John Burns from SECEBA is on camera, and he's going to participate today for SECEBA, and I'm going to drop out.
Okay. All
Okay,
right.
thank
That's
you.
all right.
Thank you,
That's
Mr.
all right
Witt.
with you and everybody. I'm happy to do that. Good morning.
Yes, sir. Good morning, Mr. Burns. Okay, did I miss anyone?
Thank you, Richard.
Okay, everyone, what I've done, I've silenced my phone, but I should be able to watch. We're going to take our first break at 11 o'clock. I checked with our court reporter, Ms. Jo Wheat. She said an hour and a half. Stopping at after an hour and a half would be a good time to take a short break. So if you don't mind, unless someone has a problem with that, we're going to stop at 11:30, okay, to take a break. Okay, next I need to ask our stakeholders a question, or a couple of questions. Does anyone object to this procedure being used for today's public forum? So I will call upon each stakeholder in the order the comments were filed on DMS. And then if you say, I don't have anything at this time, I appreciate it. And I will move to the next entity, person. After we complete that first round, I will then go back and ask, for example, I'm going to ask Ms. Edwards again. Ms. Edwards, do you have anything that you want to add at this time, having heard all the stakeholders' comments? She says no, then I'm going to move on to Mr. Turaney, so on and so forth. The final thing is I have a couple of items that I need to ask your comments on. One being, for example, a date that I've come up with for any follow-up comments to be filed. So I just have a couple of items that I need to ask you about when it's my turn. Does anybody have a problem or an issue with that procedure?
How about
Mr. Anselmo?
just a question?
Okay.
Are we going to do each topic individually, one at a time, or do you want us to talk about all the ones in our letter all at one time? It might be more efficient to.
Well, I was thinking that you could talk about, I can either use the notice and then ask Miss Edwards, for example, first, but I realized that in Ms. Edwards' letter, she said that her client didn't have any comments right now. That's why I recommend perhaps you as individuals, please present any comments that you have that you may want to summarize. If you want to just refer to us to refer to your comments for most of your comments, your written comments, that's fine.
I asked a poor question. I meant, do you want us to talk about item number 1 in the notice, stop, let everybody else talk about item number 1, then we move to 2, or do you just want us to roll through our comments one entity at a time?
I was going to use the latter first, unless you all don't want to.
That's fine.
No, I think that's
Just want to make sure I was
Okay.
doing it right.
Okay. All right, let's see. I think I told you everything that I have. Okay. So, Ms. Edwards, please.
With regard to the process that you've outlined,
Yes, ma'am.
I'm perfectly fine
Okay.
using that process. And then did you want to go straight to the first item, notice of public hearings, or just stop there?
Okay. Let's see.
I think we're just talking about everything.
Everything?
Yes,
Okay.
everything.
Robert, is what
And
I
then,
gathered.
which is follows, okay.
Yeah.
So, with regard to the public forum and the feedback that you've solicited,
Mm-hmm.
for the South Carolina Telephone Coalition in particular, many of these items, there are some matters that we routinely file, but our perspective is that the commission has an excellent docket management system. We are aware that there are some provisions from the recent Act 41 that will cause the commission to maybe take a different view or have to incorporate some of those provisions as part of this public forum.
Mm-hmm.
We specifically just requested the opportunity to kind of hear the comments
Mm-hmm.
and then come back at a later time with any responsive comments if that were permitted.
Yes, ma'am. That's part of the third part that I was going to discuss with you all. The plans after today's forum.
And in its summary, that we had very short comments.
Well, we appreciate it nonetheless. Thank you, Ms. Edwards. Okay. Mr. Terani?
Thank you, Ms. Boyd. We submitted some brief comments. I think the gist of them is we would urge the commission to maintain the flexibility that it has now. So with items like pre-hearing briefs, I would not want to see a default rule that says we want pre-hearing briefs. I've been in many hearings where pre-hearing briefs would just simply add something to do for everybody. I've been in other hearings where people felt there was a need for them, and they said so. And at that point, the commission set a schedule for either pre-hearing or post-hearing briefs. So we would urge flexibility through the status conferences, which you asked for comments on. I think they're very helpful for establishing procedural schedules. Perhaps a brief conference could be held sometimes on filing when there are dates to be set, because we find notices are issued and then the parties come back and say, well, we really need to change the schedule or something. So I'm not saying in any case I trust the clerk's office's judgment in doing that, and that's fine. With regard to the live streams that you asked for comment on, we do think they're helpful, and I would like to agree with the comments of other parties that said that they believe the ex parte briefings could be live streamed.
Oh, you agree with them on that?
Yes, ma'am.
Okay.
And I believe, I'm not sure which party said this, but they were wise in suggesting that the archives could be organized in cooperation with ETV. The YouTube channel is useful, but it's somewhat hard to navigate sometimes.
Okay.
With regard to the changes that were made in the recent legislation, which came about, I believe, after this forum was noticed, I think these are all worthy topics of discussion, and I look forward to hearing what people have to say about them today. But I would also urge the commission that perhaps it would be appropriate to convene a separate proceeding for those, or at least a separate session of these proceedings for those, and devote a day to them, because I think there's a lot to think about in there.
Okay. So thank you for a couple of things. If everybody doesn't mind, I was going to provide information on two different topics that Mr. Terani just spoke about. Not Act 41 specifically, but I have two documents. And because when I read the comments, it seemed to be an overriding theme with a lot of the written comments about perhaps consistent scheduling, consistent procedural status conferences. And so if you think that this document that I'm about to show you is should be reserved, or this discussion should be reserved for whenever the commission, should it schedule just a separate session devoted solely to Act number 41, please say so. But let me pass this out. Live stream team, let me find it on so that Mr. Burns can see it too while I'm displaying this document, while I'm distributing this document. I'm going to make it smaller. Would you mind, Ms. Purvis, showing that to Mr. Attorney Burns?
Thank you for the consideration. I appreciate it. I can see it just fine.
So the document I've just given you is one of the topics or one of the matters that I was going to ask you about at the end. But, and as you can see, there's mention of discovery deadlines for certain phases of a commission proceeding. And if you don't think that this is appropriate to talk about today, I had a couple of questions in my mind. For example, would a checklist like this be appropriate if the commission just issues a notice of filing? Or would a notice of filing and public hearing trigger a status conference like this? So that was my reason. But if today is not the right time to talk about this, if this separate session that you've inquired about, Mr. Toraney and everyone else, is appropriate, then that's what we will do. Okay, so I didn't mean to interrupt. I wanted to just mention that. The other thing is, you mentioned ETV, just so everybody knows, because we had a couple of stakeholders, and we appreciate your comments regarding our archive videos on our website. So our team had already, basically, I have to give them credit, they had inquired into this matter before. Am I right, team? Okay. And so this time, they inquired again. And when I say before, I mean prior to receiving these comments in the non-docket. ETV responded that they had on Thursday, June 12th at 10:56. We have a response from our web development partners. This request is estimated to cost $175 per hour and take approximately 8 hours of work for a total estimated cost of $1,400. And we asked them about adding some type of search function feature for our videos. I emailed Mr. Goodwin again this morning and asked him, based on the comments from Mr. Wellborn and Mr. Hall, what actually would be included, what type of search function would be included. Would the researcher be allowed to search by docket number, date, keyword? And so I'm waiting for that response. So I just want you to know that we have contacted ETV. We do have a quote. I just would like to have more specifics about what we'll be receiving for the payment of $1,400. Mr. Toraney.
I guess my question is, if I understand correctly, what's happening now is a certain number of hearings are archived on ETV and the rest are on YouTube?
So
is that right?
we were going to incur a charge because of additional charges,
Right.
because of the capacity that we were using for our videos. So we had to create another place to
Right.
move, or we would start having to pay extra charges for our videos. So that's why YouTube exists.
And I'm not questioning that, but my point would be the ETV search function is great, but it's going to be limited to the past however many you keep on ETV.
Yes,
To
sir.
me, the harder, and I would welcome it, because we have to kind of go through the pages and search for the docket number, but they're basically sequential and by date. My bigger problem, and maybe it's because I'm a boomer, is navigating YouTube.
Oh, really?
I think those YouTube archives are confusing.
Okay. Well, yesterday I had to, I internally sent an email with a link to, and I understand what you're saying. I was searching for a particular docket, and the sequential number in the middle was so high that YouTube only returned the, results relating to those two dockets. I met with the project management office team yesterday afternoon, and we looked at some other issues related, because I told the team, look, I searched for another docket and it had, the middle number was a 1. So YouTube then returned several videos, but they weren't the videos that I was looking for 2024 1E. Okay. Our IT manager was in the room, and so he tried to search by quotes. And of course, with the quotes around it, it returned exactly those videos that we needed. But the public, we can't modify YouTube's webpage like we can our own, or
Right.
like our DMS Fest search that hopefully you all have seen, where you can let the public know, look, this is the correct way to search for a YouTube video. So we'll need to look more into that, Mr. Toraney, what we can do with YouTube, or do we have is there another platform we can use for our archive videos? So we will definitely look into, as I understand, I just experienced that yesterday, and I was actually, like I said, I was looking for the videos for someone else. And I noticed with the number, I'll tell you which one, it was 2023 89E. And everything, including a pre-hearing conference that was held, appeared as a result. But then searching for 2024 1E, everything. I mean, just a list. So I know exactly what you mean.
Thank you.
Yes, sir. Okay. All right. Does anybody, the list that I gave, you can just let me know, Jocelyn. I think we should not talk about that later on today, and that's fine. I just wanted you to see, as I said, when I read the comments, there appeared to just be the theme over and over about conducting, scheduling procedural status conferences probably as soon after the initial pleading was filed. And so if that is what is going to end up happening, I do think maybe we can talk about that. And if you say no, now is not the time, later on today, that's fine. Okay? All right. So now, Mr. Anselmo.
Thank you, Jocelyn. I'll start with the checklist that you put up since it was
Okay.
here, and then I'll move into the letter.
Okay.
And I'm sure there'll be more time to flesh this out, as you mentioned. But Act 41 does impose a requirement for procedural schedules. And I know everybody likes a status conference, but quite frequently we all agree on schedules. So it might be more efficient for the commission to issue a schedule, and in the event we need modification of the schedule, then maybe hold a status conference to talk through the modifications. Otherwise, it's more just like a roundtable discussion of things that we probably could have handled by email, frankly. So mindful of commission time and the party's time, it might be, and I think in accordance with Act 41's requirement that the commission should issue the schedule, just issue it, and if we need changes, we'll let you know, then have a status conference that way. Now, we can flesh that out more as needed, but those are preliminary thoughts from the company on that. Then as I turn to our comment letter, I'm not going to belabor it. Y'all have the letter in the record. But as far as notice of public hearings, the key takeaways from the company is if the commission could be mindful of the length of notice as they get longer, especially pass over one page, the cost goes up greatly to print these things and therefore to the customers. And then the company needs sufficient time to get them out the door. And I think as all the utilities here, we're on cycle billing. So not necessarily every customer receives notice on the same time because their bill comes out at a different time. So it's not get it to everybody in 30 days. That would require a special mailing, right? We're trying to avoid that, reduce the cost. So be mindful of the time needed for the companies to get those out on cycle billing. Public hearing, scheduling, location, I think our comments on that speak for themselves. They're very valuable, but at times they're not attended. And there are other opportunities for customers to attend rather than incur the time and cost to go and hope somebody walks in. There are other forums. They can participate online. And I think that meets the requirements there. Pre-hearing briefs, we echo what Mr. Torini said. Flexibility is good. I mean, these cases are papered up well with testimony, applications, numerous exhibits. I think the commission is well versed in most issues that are present in the cases, but at times pre-hearing briefing could be important on unique issues, motions, etc. Other parties use pre-hearing briefs differently. We don't see an issue with that. The flexibility is fine. A blanket rule could create problems where none exist, frankly. Status conferences, I'm going to kind of talk 4 and 5 together. The process that works now, conclusion of the hearing, we all get together, talk about it. It's very easy to come up with a date on when, orders are due, proposed orders, things of that nature. And also through email. If we don't talk at the hearing, usually an email goes out. Parties are very easy to accommodate whatever date the commission needs. And then in dockets where there is no set deadline, same thing. The company, if it has a timely deadline or a deadline that needs to be made aware of, we let the commission know in the application or as soon as that deadline becomes obvious. And, as you pass out the checklist today, I think you incorporated possibly one of the comments we had. Let's just put the deadlines in the initial checklist of procedural status of the case. And if it needs modification, it can be modified. But again, mindful of the commission's busy calendar and the folks in the room, probably don't need a status conference to set the deadline for a proposed order. 6, 7, everything's working great there on the business meeting time, the docket management system. It really is an excellent system. Frankly, I wish the circuit court employed something as user-friendly as the Public Service Commission does. Ex parte briefing, I think y'all run that well. We commented, and we've talked to some of the parties, that a live stream option would not violate the statute because it'd be listen only. And the purpose of the ex parte statute and the reasons that the folks in the room have to sign in is because those are the people who have the opportunity to interact and discuss issues in an ex parte fashion with the commission. Folks watching online have no ability to interact, can't talk. It's a listen only line. Y'all use it all the time. And, you know, I know y'all publish the documents and stuff rather timely, but sometimes you do need to watch them in real time and can't be here in the commission room for various reasons. Because the issue is important or relevant to something that's going on, and you know any delay impacts decisions that could be made. So I think a live stream option there certainly is compliant with the statute and would help out the parties and the public. They're used to y'all live streaming stuff, so they'll be able to find it. The consultant process, look, it's set forth in statute. I think the commission does that in a transparent way in accordance with the rules. The company had no additional comments there. And then I'll summarize our position on the other customer complaint procedural schedules. Consistency in scheduling and a schedule that accommodates motions practice, either motions to dismiss or other dispositive motion, and allowing sufficient time to get a ruling on that motion is important. We don't willy-nilly file those motions. We do that because we think that the complaint lacks merit and should be dismissed in order to save the time and expense to our customers for preparing testimony and hearings. So if the schedule affords the opportunity to have a ruling, it would help on that line, and also give clarity to the company on what's going to happen on the day of the hearing. We put in a sample schedule. The dates are wholly irrelevant, and it's more of a see the spacing that we think is necessary in order to accomplish what I just discussed.
Jocelyn, good morning. I'm sorry I was late. We've got a number of filings that we're making today at the commission, so my attention was diverted to that. With respect to customer complaints, I do think that we probably need to have a look at that. Because I don't think customers appreciate the process that they're initiating when they file a customer complaint. I don't think they intend to, or I don't think that they believe that lawyers are going to get involved. Motions practices is going to be happening. We've had a couple of recent customer complaints where we've had a room full of people, and there's a lot of time, money, and effort involved in that, and customers don't show up. And secondly, the matter's already been reviewed by another agency before it even gets here. So I don't think that's a topic necessarily for today, but we did want to put that on your radar, that as we're seeing the number of customer complaints rise, and for DESC, we've got I think 6 pending before this commission now, which quite frankly is been unheard of in my career before the commission, that many. I think something needs to be done to help that process along. I don't know what the answer is, quite frankly, but I do think it's worth discussing because I do think customers want to get their matters resolved quickly. I think ORS does a great job of being very efficient in that manner. And then once they come over here, they kind of just they follow the process, and the process is just a little probably not endearing to the customer at the end of the day, and it's also not endearing to the company either, because we're having to spend time, money, and resources to address a matter that another agency's already dealt with. And I understand the reg says what the reg says, but I do think that would be worthwhile of a discussion in the future. But at a minimum, you ask us for our comments on processes here at the commission. I think y'all get an A for what y'all do here. Y'all are fantastic. We love working with y'all. But as far as customer complaints goes, I think there is some room for improvement in that area.
Okay, thank you both. That's another topic that I have that was on my agenda for my part of our discussion today. So we'll be coming back to that topic. But Mr. Anselmo, thank you both, and Mr. Burgess. May I ask you just a couple of questions? When you mentioned the length of the notice and you mentioned a page, are you talking about when we send it front and back? Because we tried to, after we held some forums during COVID, and we restructured our notices to make sure that they were no longer than 2 pages. So when you say 1 page, do you mean front and back?
We do. We mean front and back. And you're right. Y'all were very attentive and y'all listened to our comments about that. Whenever we do a bill insert, the insert is as big as the width and length of the envelope.
Okay.
And anytime you have a notice, we do our best to crunch it down to 1 page.
Okay.
You don't want it to obviously look like some disclosure policy from a credit card company where you have to pull out a magnifying glass to read it. So we're mindful of that.
All right.
So that was the only thing that we're just reminding y'all of. Again, you've done great. But if that notice, for whatever reason, starts to grow, if a commissioner has an idea or staff has an idea, if it spills over to another page, it does just add a little bit more burden and expense to the process.
Okay, understood. I know we talked about that when we had our forums during I say COVID, but it was around that time frame. I think everybody remembers. And then I wanted to make sure I understand Duke Energy Carolinas and Duke Energy Progress, when they file a pleading that requires notice, they ask us to at least give them 55 days to provide the notice to their customers. I think Dominion asked for 45 days. Is that still?
That's right. We're a little shorter, and I'm not sure that I appreciate the differences between 2 companies, but that's exactly right. In fact, we had an issue just come up yesterday where there was a notice that was issued.
Mm-hmm.
There was a quick turnaround on that. We appreciate y'all getting that to us in advance. And I was able to have communications with the folks who put those matters together as far as newspaper publication and also for bill inserts.
Okay.
And the timeline that y'all had set forth in there was acceptable as long as we got it out yesterday. And y'all did a great job. Appreciate y'all getting that back to us very quick.
Okay.
So, but yeah, that timeline's still the same.
We want to make sure 45, I think for your clients, Mr. Terani, is it 45 too for Mr. Terani? Is it still 45 for your clients?
To be honest with you,
you don't remember anybody else who has clients, and we're trying to be mindful of the costs the customers will incur. So we try to do our best to incorporate the days that you've asked once we issue the notice to provide you that time frame to get the notice to your customers, so it's in the regular billing cycle. So I may be missing some clients. If you haven't notified staff of how long you need to get that notice to the client, to your customers within your normal billing cycle, please let us know. Okay. I need your brains again. So when you talk about the public night hearings where they're not here. I mean, as you are aware, the commission travels, commissioners and staff. And something that I think we've struggled with internally is the company has provided its customers with written notice, either by electronically or by U.S. mail, that the commission is going to conduct a night hearing in their community, somewhere in their community. And so what we have struggled with internally with just canceling, even though maybe not many people have registered, is we're not sure who still may appear. Maybe they don't have access to the computer and they learned about they missed your notice and they learned about the public night hearing from Rob's public information notice he sent to the media. You know what I mean? So that is difficult for the commission, even though at times we know many people have not pre-registered. And our concern is that members of the community, your customers, may still appear, even though they have not registered. Maybe they missed that part about asking, or they just decided, I'm not going to register, I just want to go. Do you have any thoughts on how we can address that? Because those are the people that we're concerned about too. If we have the email addresses and telephone numbers of those who've registered, there was a case that was pending and it was in Columbia. It was not at the commission. And what we ended up doing, Commissioner Belser met me at this location. It was at the beginning of COVID, and we just went and met people at the location. It was in Columbia, and said, look, we are having to reschedule this. That's a little bit easier. than maybe driving to Greenville, perhaps. I don't know, but I'd love your feedback on that.
No, the company is completely mindful of that concern, and do understand it and agree it's not a simple solution. And we didn't offer these comments to sort of in any way diminish the ability of the customers to come. We think there are other forums that they could, either another location or an online. People call in to ones all the time.
Okay.
If you're looking for a possible solution as to sort of the walk-in situation, the notice could say you have to register to attend.
Okay.
But look, again,
It's your suggestion.
That's just a suggestion,
I understand.
and not trying to diminish anybody's ability to come in. We appreciate the feedback. It's actually very beneficial for the company to hear that. But that's just a suggestion to save. You know, it happens, like you said. You go to Beaufort and there's nobody there.
Yeah.
Things of that nature, and that's why we raised it, just to have this discussion.
Okay. Well, I want y'all to understand too what has happened when we have, and people have still appeared. Of course, it was the beginning of COVID, but we were there. Staff was there to kind of direct and look. We're going to reschedule this, so on and so forth. That's our dilemma.
And Jocelyn, the reason that I even suggest the registration thing is it does help the company know who's in attendance, so we can look at their account information and maybe get ahead of any complaints that need to be addressed that the customer brings up at the hearing, right? So we can solve the problem. We give the number. Back in the old days, there used to be customer service representatives available in the lobby, those type of things. So if you have the information on the person, you can know perhaps this is what they're going to talk about and be ready to roll.
Okay. And we're going to come back to that because Mr. Wellborn mentioned that in his letter too about our list that we provide of public witnesses. I want to ask him just to elaborate a little bit more on that. And you may want to chime in, Mr. Anselmo, once we get to that, your second round. Okay, let me see what else I have for you. Okay. And as I said, we're going to come back to the customer complaint process. And here, I think it's more of the individual customer complaints that we're talking about, because if the complainant is anyone other than an individual, they're going to have an attorney. So that's what I'm mainly talking about. And based on the schedule that you provided, Mr. Anselmo, the process would take about 100 days, basically from the beginning to the hearing. Now, one thing that the process could take a little longer depending on the availability on our commission calendar, right? So even following what you have here, just be aware that it depends on when we can schedule a hearing based on, who's here and that type of thing.
Certainly understand that. And the sort of length of the 100 days that you mentioned dovetails with what Chad mentioned a minute ago. We don't think the customers appreciate the effort and time that goes into a complaint of this nature when they file their complaint. And it does take time, but it's the nature of the process, and I'm sure we'll have other opportunities to discuss this, that the company still needs the time to prepare testimony that is reasonable to do so, to assess the complaint, to determine whether a motion is proper, to file the motion. We still have those procedural due process protections, just like the customer would on their end. But it is a process that, once triggered under the current way it's approached at the commission, is a time-consuming and somewhat difficult process for the pro se litigant or a represented litigant and the company. So that's why we proposed a sample schedule like this to give everybody the ample time needed to address the situation.
I want to pry again. This wasn't even on my question list. I promise this is my last one. Let me flip my page. Nope, don't have anything else after this. This just came to mind. How long does it typically take for you to conduct discovery?
In customer complaints or in general?
Customer complaints.
It is infrequent that discovery is conducted in a customer complaint docket. We've had several, and I can only think of one instance where it happened, and that party was represented by counsel. There was the new Act 41 requirement. The office has been sending notices out. I'm not going to address that, but this goes to that. discovery imposes an ongoing obligation on a party who receives discovery.
Mm-hmm.
So there's really no set deadline until you got to complete it 10 days before a hearing. So if you send discovery, we send discovery to the consumer advocate with our application. It doesn't matter that the application gets filed. Roger's ability or obligation to supplement and answer those continues until the drop dead date. So again, to your specific question, it is very, very infrequent that is needed, and it's almost difficult to anticipate a situation, unless it's a unique one, where we would need to, because the records are in our possession that answer the complaint.
Okay. Thank you. Thank you, Mr. Anselmo and Mr. Burgess. Mr. Muschin. So, yes.
So, Mr. Burgess said that he would give the commission an A.
Mm-hmm.
I would give the commission an A+.
Well, thank you. Thank you.
Oh my God. Did you bring an apple?
So I don't think I would disagree with anything that's been said. I would.
Okay.
There were a couple of things that I was going to just point out. Mr. Anselmo mentioned the allowable ex parte and the live streaming. So we've talked about that internally. We're still kind of mulling that over. I certainly understand and appreciate their concern and interest in watching it live stream. I think, from our side of the house, we're the ones that have to certify. And so I think we could figure out something that resolves all those concerns.
Okay.
But we're still kind of thinking through that right
All
now.
right.
So on the procedural schedule, I think Mr. Anselmo mentioned having the commission issue a procedural schedule first. And while I'm certainly not opposed to that, but, in a number of events, the parties are able to work out a proposed procedural schedule on the front end. So, I might consider building in a little bit of time to give the parties ample opportunity to have those discussions and present a proposal to the commission. If the commission decides to go ahead and issue a procedural schedule and we need to modify it, then certainly we can propose those modifications. But I would at least let y'all think about that. Notice of public hearings, so I don't really have anything to add. I will say I talked with our consumer services folks this week about that. I believe, and I can't remember now when it was, a few years ago, there were some discussions on notices, how to make those more clear, easier to read. In particular, we had been receiving a number of calls from customers not understanding what it meant to intervene. Did they have to intervene? Those types of things. So those numbers of calls have gone down significantly. So we feel like that was a good effort by everybody, and that has been successful in that regard. There was a little bit of discussion about scheduling. I think the only comment I would make on scheduling is scheduling has gotten, at least in my mind and based on what I've seen in my practice, significantly more difficult as far as time frames, especially in rate cases. We've got there's a lot of work to do in a short period of time. I fully acknowledge the commission needs time on the back end to consider the record and make its decision and issue the order. It seems like it is becoming more of a struggle as we build in more and more time. And I'm not saying that's necessarily appropriate or inappropriate. It just is what it is. To give the parties the ability and have ample time to conduct its review and provide testimony that's meaningful to the commission and it's useful. So don't have a recommendation in that regard, just more of an observation. The complaint notice of hearing, that Mr. Anselmo was talking about, I don't have any issue, I don't think, with what he said. The one thing that did kind of jump out at me, which I had mentioned to him the other day, I think they had proposed issuing a notice of hearing after testimony had been filed. While I'm not really opposed to that, these complaints often, especially if they deal with a rate issue, the billing's been suspended while the complaint is pending. And so, I would just say to be mindful of if you do it after the end, then that potentially is another 30 days, and that may elongate the complaint proceedings, and you just may want to think about that. Night hearings, no one showing up. I've in my practice, I've seen that happen a time or two. It certainly is frustrating. I do think there are other avenues that customers can participate, whether that's in a forum, virtually. I will comment that those night hearings, even if customers don't testify, it does give them an opportunity to interface with the company. A lot of times I've seen customers may have a service issue or a billing question, and the companies are great about having their customer service folks there to interface. So I do think there is some merit in that. But obviously that comes at a cost that ultimately ratepayers are going to pay for. And so I don't have an answer to that. I think that's been around for at least in the 20 years I've been doing this. So, and then the last thing I would say, and I agree with Charlie's comment about the Act 41, 3309 changes. I think another forum would be good. And I don't want to drop a grenade in the middle of this. And Mr. Welborn and I have had a number of spirited discussions about testimony, sur rebuttal, the manner in which it goes. And so I won't dig into that too deep. I think the only thing I would say is we certainly recognize that Act 41 has put some guardrails around that. What I don't want to do is I certainly want to follow the statute and give the company what it's entitled to under the statute. What I don't want to do is to have that done to the detriment and the inconvenience of other parties being able to provide and prepare their case in the manner that they see fit. And so, I was looking at your checklist. I think, and I don't want to get into it. I think this is a better discussion for a different forum.
Okay.
I think what y'all have laid out is more along the lines of what we were thinking.
Okay.
But that's what I've got for right now.
Okay. Well, thank you, Mr. Mushkin. One thing I was going to say, and maybe when we have the Act 41 forum, when you mentioned certifying the record for allowable ex parte briefings, I think one of the questions I'll have for you is it constrained just to commissioners and commission staff now, like for those certification statements, unless we attend a site visit? That was one thing I was going to ask, but I don't have to ask it today.
Let's not talk about that today.
All right,
I'm
no
still
problem.
figuring that one out.
All right, well, then you know what I was thinking. And then the other one is, I will say, when we are provided procedural schedules with the initial pleading, it does help us. Even if the date is not available, I think if ORS is copied and Department of Consumer Affairs, and you ask us whether a date is available prior to a hearing date is available, I think that's helpful for everybody.
Okay, and I think that's a fair request. I do know when we do try to work out a proposed schedule on the front end or before an application is filed, we do try to go look at the commission schedule that's on the DMS.
That's online, yes, sir.
Sort of things. So,
but sometimes commissioners they could be on leave, already scheduled leave, or they could be in training, and that's my only reason for encouraging you. Then if you, at least if it's a citing case, you have to copy the other people. Not the other people, but the statutory parties. But we don't have a problem as long as you and Mr. Hall are copied on the email letting you know if a date is available. And I think that may be helpful, because when you see that where we've changed it at times, more than likely there's a conflict.
got it.
Okay. I'm sure Ms. Wilson or Ms. McMullen, they will not, that doesn't bother them. Am I right, Ms. McMullen? It doesn't bother them for you to ask.
Yep.
Okay, that's it right now. Thank you very much, Mr. Mushkin. Mr. Welborn.
Hey, Jocelyn.
Good
Thank
morning.
you. Thank you to the commission, and thank you to you and your staff and folks here for organizing this. This is helpful. I'm just going to burn through a summary of our comments.
Okay.
And then we can focus in on things as you'd like to discuss things more.
Okay.
If that's all right.
All right.
So we, in general, believe that the clerk's notice of public hearing process is efficient, effective, timely, fair, user-friendly. We've had robust attendance at public hearings, and so we think that what's being done currently appears to be working. On topic 2, public hearing scheduling, location selection, et cetera, we believe that the current process is effective and efficient. Again, we're seeing folks turn up, and so that's evidence that the process is working. One of our concerns is the safety of our folks and y'all, which I'm sure, you guys do your own vetting for that. And so I think we've checked that box.
Okay.
And that the time allocation is efficient and fair in terms of ensuring that we're making progress and that we're not going to be there all night.
Okay.
As relevant, I guess, to Dominion's thoughts on, whether public hearings should move forward or not if folks don't have, if there aren't signups ahead of time. One option would be to set it as a virtual public hearing, just to reduce the demand logistics, the logistics demand around those events. But
okay, now when you say that, I'm sorry to cut you. Tell me what you envision when you say a virtual. Now, the commissioners would be here.
Right.
Okay.
They could be here or presumably could be virtual, but the commission has set virtual public hearings in the past, and so I guess if you don't have enough pre-registration, you could change it potentially to a virtual public hearing. Of course, the timing would be tricky, especially if you have 1 or 2 registrants. Are they going to show up in person? Yeah. So there are details there to work out, but in general, it could be a potential path for y'all to think about. Okay. And we don't feel strongly about it, just sort of some ideas.
An option.
Right.
Okay.
On topic 3, the value of pre-hearing briefs, the matters that come before this commission can be pretty complex and complicated. Typically, they're intertwined with matters of law, particularly with new law coming out. Act 41 is an example. So, when you have novel issues of law, it's helpful in our view to tee those up for the commission and to kind of orient as to how we're viewing the law as relevant in the context of a particular case. And so we think there's value, at least in certain cases, to pre-hearing briefs. Of course, not in every case, but that they do have value in terms of orienting the parties in the commission as to our view of how the law was intended to apply in a particular fact circumstance. For topic 4, the value of pre-hearing, post-hearing, and status conferences on proposed orders. Again, we think the process is efficient and effective and fair. Setting the proposed order deadline ahead of the hearing in certain cases can help establish expectations in terms of the pace and cadence of the case, but we think that in general is working well. On 5, the value of pre-hearing, post-hearing, and status conferences on the time frame to issue commission orders. Again, we think y'all are doing well where those deadlines are not governed by statute. For example, a 300-day proceeding or a 6-month proceeding. There could be some benefit to the parties and the commission setting a target deadline for that. Just again, given the pace and cadence of particular cases. Pre-hearing or scheduling conferences can also be valuable and in line with Act 41, as I mentioned a moment ago on topic 4, where the company we also have additional information or filed comments on that. So I won't go into detail, but Section 7 of our filed comments about additional regulatory processes. Topic 6, commission business meeting time and schedule. So we appreciate the commission issuing agendas, well out in advance. That's been helpful so that we know what's coming up, what's coming down the pike. And then we also like that the commission splits the agenda between transportation and utility matters. That allows us to, attend those more efficiently and effectively. On the DMS, topic 7, like others have said, it's a great system. We think you guys are doing really good work. It's easy to navigate. And we think, we think it's really effective and is accomplishing its intended purpose. We also appreciate that the commission is quick to post filings once they're made. So I know that you guys have internally reviewed. We went through workshops and things on that, and we think you guys have done a marvelous job in that department.
Just so everybody knows, too, just about another internal process. If a case involves a change in rates, there's another internal process that we use. So if you see a lag, Attorney Wellborn mentioned that it's because we have a team, for example, the CPA, they're looking at the application and comparing it to what's in the regulation. That's for everybody's knowledge. We don't post that anywhere, but we're looking to see if the application contains the information that's in the regulation. And that's for any case that involves a rate change. Just wanted to let you know about what we do internally. Okay?
Thank you. For topic 8 on allowable ex-parte briefing process, we have used this tool. We think it's helpful, at least from our perspective, in providing education about different topics that can be, difficult or complex. We think that you all have been very easy to work with in terms of scheduling those and getting them set up and the logistics and all that. So kudos there. We do think that the ability to live stream briefings could be helpful and make them more effective so that other parties can view them in real time without having to travel to the commission. That's our view on that. For topic 9, the commission's process for selecting consultants. We think that y'all have developed an efficient and effective process for that. Our primary concern is about unallowable ex parte communications, which again I think was evolved under Act 41. So there's some new language there. We think the commission is handling that well. We all take that prohibition seriously, and we think the commission does as well, and appreciate the work there.
Okay.
On the last topic, topic 10, the commission's website and live streaming process. Kind of like Mr. Torini, I think in general it's helpful. It's 100% helpful to have the ability to go back and find old videos, like what was that about, or what was said there, that kind of thing. The search, the ability to navigate and search is tricky, and it sounds like you guys are addressing that. So we look forward to seeing what improvements are made there.
Okay.
We also had a couple of other comments that are sort of woven into some of these topics, and then maybe also under the catch-all of included but not limited to these 10 topics. So
That's right.
If you'd be willing to.
Yes, please.
And again, I'll be quick, and we may have other things to share as we continue to have this conversation. But
okay.
One of the substantial evolutions of Act 41 was the General Assembly's recognition of the applicant's right to open and close its case. That's going to ripple through a variety of these things. I think, for example, the sketch procedural schedule checklist that you've handed out. We think that that revision to the code, and this is all in our comments, this is nothing new, but that it conforms the commission's practice with civil practice in terms of allowing the party with the burden of proof to close its case. And we think that, it will require some new thinking and some evolution of how we address hearing procedure. And so more to come on that, and we can talk more through it. But we did present a couple of options in our comments in terms of how practically that General Assembly requirement could be implemented. One was to have the applicant file their direct testimony, present their direct testimony, other parties present direct answer rebuttal. And then the applicant present its rebuttal as well as, any new responsive testimony that may be warranted. And then there's this option B of presenting responsive testimony to close the case after all parties have presented their pre-file testimony. And so, we I think we'll need to take the proposed checklist under advisement. I think one flag that I might make is that if the applicant is filing responsive testimony, pre-filing responsive testimony, it may foreclose the opportunity for the applicant to respond to live testimony. So new issues that the commissioners, for example, may have raised during the course of the hearing that implicate the party with the burden of proof, their right to close their case. So that's something to think about. But like Mr. Mustin and others, I think we'll need to spend a little more time thinking about this on our own, and then maybe come back. Okay, if that's all right.
Yes.
And then right to appeal on the notices of public hearings. The comments kind of speak for themselves there, but we are aware that there is, if you think of a Venn diagram, there's some overlap between those who are participants in PSC proceedings and those who have the right to appeal, or who have standing to appeal, but not perfect overlap. There are some that sort of fall outside of that overlap, and so we think that there could be some room for improvement there on the notices of public hearings.
Yeah, I typed that somewhere. I'm trying to find it where you mentioned the language. You included some alternative language. I mean, I know where I had my own notes, but let me find your comment.
Sure.
Yeah, that's, tell me, Mr. Welborn, please, what page? I should be able to find it easily because right to appeal was in bold. It should stand out to me.
I had it in my notes, but
Here it is, page 3. Okay, it's page 3 of your.
Oh, right up front. Yep.
Yes, on the bottom
Right.
of the page. Your recommended language for that's.
Yeah, so certainly parties who have standing to participate in commission proceedings, I think, would have the right to seek reconsideration of commission decisions, which is, more or less equivalent, I think, in the commission's language in the notice to appeal. Appeal and reconsideration are kind of used interchangeably at this phase. And then the formal right to appeal to an appellate court is a separate right with separate case law and separate standing requirements.
Okay.
Hopefully I'm looking at my outside counsel to make sure I'm not butchering this too much, but
No,
I'm seeing nods.
No, and there's some case law about this. I think, the status of an intervener doesn't necessarily translate into appellate standing. And
Okay.
so, there's concerns about putting that in a notice up front that it could cause confusion to folks who want to intervene. And then certainly, the companies are usually directed to provide these notices. We wouldn't want to waive our rights to contest that at a later date. If need be.
Okay, thank you.
And then one last quick topic. I know I've gone
No,
on.
please continue.
Thank you. So procedural schedules, very important, I think, to everybody who participates in commission proceedings. And again, appreciate the sort of sketch checklist as something that we can think more about. In general, we believe that enough time needs to be baked in between the deadline for surrebuttal testimony and the commission hearing. It allows parties to talk about settlement, for example, and knock on wood, hopefully file that soon enough for the commission to consider ahead of the hearing convening. It also allows the party with the burden of proof to prepare for the hearing and get its witnesses ready for the hearing, and also decide whether additional testimony may be warranted on a case-by-case basis based upon what comes out in surrebuttal. Another thought is the need for discovery on surrebuttal testimony. So, it's supposed to be limited to new matters that are raised in the applicant's rebuttal testimony. That's not always the case. And so rather than, going through motions practice, motions to strike, et cetera, one opportunity could be for the party with the burden of proof to propound discovery on the party filing surrebuttal testimony and or potentially pre-filing responsive testimony in accordance with Act 41. But again, I think that's a detail we need to think more about offline and get back to the commission on.
Okay, perfect.
One last thing on that point is that we believe that, so I already covered the 21 days between surrebuttal testimony and the hearing. And then, that's right. So, an opportunity to file pre-hearing briefs as well during that time period between surrebuttal testimony and the hearing, should it become necessary or seem necessary.
Okay.
If it's all right, I'd like to invite Ms. Smith to see if she has anything to fill in the gap.
Yeah, I just wanted to speak a minute or two on public hearings. And security is something that we flagged in our testimony. It's a passionate world. And we've seen violence served upon some of our folks in the field. That has started to bleed over to even some of our administrative employees, where we've had threats on our administrative employees. And I know that I've certainly had experienced this myself. And sometimes public hearings can be, sometimes very few people show up. Sometimes in a large room, it can be standing room only. And so I just really wanted to underscore that security is top of mind for us. And it's not in every case, but, frequently in rape cases, there can be, a lot of levels of passion, for thorny issues. And so we do appreciate the advanced sign-up process, because having a sense if 10 people are going to show up or 100 can help indicate, what appropriate procedures might be in place for security. And so that's just something I want to underscore. The world does not seem to be becoming a safer place, and we just want to make sure that we are mindful of the safety of the agencies involved, our folks involved. We tend to bring a lot of folks to address individual customer concerns, and we've seen more on that in the last couple of years than we have in times past. So I just, I don't know exactly what the fix is, but we do want to really underscore safety as something that we're paying a lot of attention to and are mindful of.
Thank you.
Everyone is, but I wanted to sort of speak to the acceleration of passion to near action that we've seen in a variety of forums.
Thank you.
I think that's what we
For right
have,
now.
unless you have any questions for
Well, let's see. I was just saying. So, when you mentioned the to incorporate status conferences and proceedings where notices are issued, I had a question. If you were recommending virtual status conferences, how soon after the an application is filed? If you thought about that, if you don't have an answer today, that's fine. Just curious.
Yeah, like Mr. Mushkin, I think there's value in trying to sketch out a draft procedural schedule even ahead of when we file. That's not always possible and not always the most efficient way to address it. I think of, a case where it's a relatively uncontroversial filing where, there may be comments. I think we could probably follow a general in other words, it wouldn't require a lot of legwork, I guess, on the front end to figure out what the right schedule is. But in more difficult dockets, my hope is that, the applicant would be in a position to propose a procedural schedule on the front end. More directly to your question, how quickly should we schedule those scheduling conferences? I think, getting notices of filings out on a timely basis is important. The companies themselves need at least 55 days to get, notices issued in a cost-effective way. We can do one-off mailers, but they're much more expensive, which is a cost that customers will ultimately bear. And so I say all that to say, I would, without putting a specific timeline on it, pretty quickly after a filing would be useful, just given the need to get the case moving, if that makes sense.
Yes. Let's see. So we're going to reserve, I think right now, the timeline for discovery procedural schedule. That's what it sounds like. Okay. I do have a question. So the one document with all, and I understand the employees who worked at the PSC, if you all remember, the PSC used to have its technical staff was on the second floor in this building. And when I figured out the transmittal letter and certain dates, I understand your comment about having the dates, all the dates maybe in one document. They did a tremendous job. I have kudos to those people who were employed here way before me. They did a great job, I think, figuring out how to schedule fuel cases, because that's a different schedule. If you compare the fuel schedules to our typical schedules, when notices are issued, it's not the same. So I think they did a great job. But anyway, my question is, are you, when you say maybe another document that just lists all the deadlines, are you thinking something like this? This wouldn't be titled status conference, but just deadlines for that particular docket. The deadline to provide notice in the newspaper would be incorporated in a list like this. Deadline to provide notice to customers. Is that what you were thinking about that comment?
So it's a one-stop shop for what's coming up.
Okay.
Yeah, it could reduce confusion for anybody, whether it's a customer sort of popping in, checking into a docket or the parties as well. There's also this requirement in Act 41 about phased discovery,
right?
Which we're going to have to grapple with that together, and I think any way that we can mitigate confusion and so that we're all clear as to what the deadlines are, it would be helpful.
Sure, I agree. Okay, let me look again. Let's see. Okay, I had the language in I had it here about the interveners have the right to testify, cross-examine witnesses, seek reconsideration. I had that in my notes. List of public witnesses. And you mentioned it would be helpful for you and your coworkers to be, you like I think the lists that are provided on our website, but here's my question that I wrote. How frequently did you want those lists to be published? And oftentimes the deadline to register is probably like the Friday before the night hearing. So if you have feedback that you care to share today, that would be nice if you need to think about it. But that would be helpful for us to know how frequently, because as long as the deadline has not lapsed, then persons will either be calling us or emailing us or notifying us that they want to register to testify. So I didn't know if you thought about that, but I did read your note about as far as in advance, providing the list of public witnesses as far as in advance of the public hearing as possible.
Yeah, so Ms. Smith mentioned security concerns that the companies have, and certain customers we have to be a little more wary of in terms of what behavior we might expect. And I don't mean to sound too cagey, but knowing who will be appearing at a public hearing is frankly a safety and security concern in certain instances. That aside, we also are aware that certain customers, based on their calls to our center, may have certain things that they may need to talk to folks about.
Right.
And so we, of course, make those opportunities happen offline apart from a public hearing. But to the extent, when Duke Energy shows up at a public hearing, we bring our people, right?
Sure.
And so to the extent they can be prepared for certain conversations, it'll be to the benefit of the customer who's there to speak. So there's also a burden, though, I guess, on commission staff. I mean, you can't update it every hour on the hour, right? That might be unreasonable from a workflow perspective. But headline is, there are reasons why it would be helpful for us to be aware of who will be there. And so I'm not going to be prescriptive in terms of what we would expect from the clerk's office or the commission. But the headline is the sooner we can get that information, the better, just for the company's staff safety, but also for the benefit of the customers to ensure that we're bringing the right information.
Thank you. Let's see, pre-hearing briefs. Do you think that your client would be, well, if you've worked the schedule, if you've arrived at a schedule, crafted a schedule with Mr. Muschin's office for, let's say, the procedural status conference checklist items, this question is not relevant. But if you have not, do you think that you would, you and your client would be comfortable just stating to the commission, we would like to provide a pre-hearing brief on such and such a date? I'm just curious. Let's say you haven't worked an issue, or you have not created a schedule with Mr. Muschin or Mr. Hall's office, but you want to provide the commission with a pre-hearing brief. Do you think that your client would just feel comfortable just offering that without it having been determined before with you and other parties that you there will be a deadline?
Let me make sure I'm understanding your question. So
okay.
A pre-hearing brief is not in the schedule, let's say, but then an issue arises throughout the course of a case and you're like, oh, the commission's going to need context around this issue. Mm-hmm. Certainly, I think the company would like the option of filing a pre-hearing brief in such an instance. Cases can evolve as discovery is undertaken, as testimony is pre-filed, and I have to assume that other parties would feel the same. And I won't speak for them, of course, but everything I said earlier about the value of pre-hearing briefs to me points to flexibility in a docket, just based upon what's filed. And how the case kind of unfolds. Mm-hmm.
I guess what I'm asking, because I wouldn't know. We don't talk to the parties unless, notice has been provided. How comfortable, even if it's not on the schedule, how comfortable a party would be just to offer it. Like, I don't think the regs prohibit it. I just wanted to know your comfort level, just saying, look, commissioners, we want to file this. You didn't ask for it. It's not on the schedule, but we want to provide it.
I'm going to breathe into the mic. We would be very comfortable
okay.
offering it.
Okay.
No, but frankly, we would be I think we would be comfortable, if an issue arose. One option would be, for example, to have a pre-hearing brief deadline, parentheses, if warranted or if needed, in the checklist.
Okay.
Just as kind of a placeholder.
Okay.
Which would also help, I think, with awareness. I mean, if you're, 16 days from the hearing, and it's like, oh gosh, we need to brief this issue. Mm-hmm. We've got 2 days to do it. I think it would provide a little bit of clarity. Now, again, flexibility is sometimes needed, and if there's a sort of late breaking issue that the hearing officer, for example, wants to be briefed on, then I think the parties around these tables work well together, and I expect we'll continue to work well together. So, short answer is yes, we'd be comfortable doing that. Wouldn't hurt to include an if warranted pre-hearing brief deadline in the checklist, and then two, if flexibility ends up needing, if circumstances warrant, then we could, we'd be open to being flexible, I think, on that in the future. So it's really no different than like filing a motion, for example, late in a case. I don't think there's a motions deadline, but there is in the commission's regs, as you're aware, to indicate ahead of the hearing. So,
Yeah, I see. I'm sorry. I asked that, but it says it's kind of this regulation kind of constraint it provides some guardrails, right? It's A of 103-851. Ms. Purvis, would you just thank you so much? Because I asked that question and I said, Jocelyn, better look at the reg. It's 851A, the presiding officers shall fix the time for filing and service of briefs or proposed orders. Well, I haven't talked to the chair about this, but I can tell you what I'd probably ask him is, if one has not been set, how comfortable would he be with still asking the party asking for a waiver and filing it anyway and let the commission, because even though a presiding officer hadn't fixed it. That may explain, though, why there have been some questions about. Yeah. Yes, Mr. Trey.
Yeah, I'll offer something here.
Okay.
I would just suggest that it might just be better to leave things as they are.
Okay.
Which is, people show up in a case, it develops either at the beginning they think they're going to need briefs and they ask, and the hearing officer deals with it, right?
Okay.
Or we get 6 months into it and we realize we need pre-hearing briefs and somebody asks for them. And at that point, because I think what we're forgetting is we're going to file the briefs and then we're going to have reply briefs and so on and so forth. And I don't know, there's some element of this that you really just can't schedule up front.
Okay.
Yeah.
And so I'm kind of comfortable with the way we're doing it now.
Okay. Okay. Thank you.
Jocelyn, I would agree with that. I mean, I think, the times that parties have filed a true pre-hearing brief, I mean, it's been pretty limited. I mean, most of the time, you've dealt with the issue in testimony or in a motions practice. I mean, we have filed pre-hearing briefs. Other parties have filed them. I'm not saying that it doesn't happen. It's just relatively rare in my experience. And,
okay.
And I, like what Charlie said, I mean, one thing I would say is once you set a deadline, even if it's if needed, then somebody's going to feel like, well, we got to do it. And it's going to create a whole thing. And if somebody files it or we have a deadline, then we need to bake in a responsive brief and all that. So, I think the times that this comes up is rare. I think the flexibility that the commission has given it in dealing with these situations has worked. I think there are times where pre-hearing briefs are very helpful. Other times, I don't know that it really just winds up being kind of a restatement. So I think I agree with Charlie. I think I'd kind of stay the course if you're looking to do something.
Okay. And of course, if someone wants to ask the commission to set a schedule, then you can always ask. I'll leave it alone. Let's see. Status conferences. Oh, we've already been over that. And I don't know if everybody's noticed on our DMS, maybe you've looked, if you use this FES full text search for orders, thank you, Ms. Purvis, or the FES full text search for matters, the directions now appear that we talked about at the advisory committee. So I just wanted you to know those are there. Okay? Because you mentioned Boolean and everything, and I just want you to know that our docket page has been updated. Ex parte, and you feel the commission is addressing the ex parte issue with the consultants. All right. I already told everybody about the quote from ETV. I heard Mr. Terani about our YouTube page. And then I had a question about Act 41, but we're holding that off. Thank you, Mr. Welborn.
Thank you.
Mr. Hall? Oh, is it? Let's see, Mr. Hall. It's 10:51.
I think I'll be fairly
You'll
brief
be
if you want,
okay?
yeah.
I'm not rushing you. I was just...
No problem. Yeah, as others have said, the department definitely appreciates the efforts. Well, first of all, the current status of everything with the commission and its continuing efforts to review its processes and seek input from parties. As others have done, I think I'll start with the proposed procedural schedule. I agree with Charlie and Ben that I think this is better served with another forum hearing, whatever it may be. I think really any of the Act 41 changes in with that.
Okay.
There's a lot of changes there. There's a lot of moving parts. Again, as Ben said, with a 6-month time frame in a rate case, I mean, there's a lot of considerations there that I think they're just better served for another time to give us all time to sort of continue to digest that a little bit. With that said, I guess I'll dive into the comments that we submitted. I'm not going to reread all of them. I think overall, like I said, generally positive with everything the commission did. We did offer some suggestions. So just going through the list, the public hearing notices, I think one thing that we said was maybe the commission consider Nextdoor. It's been a really valuable tool for us. It allows county and neighborhood level targeting.
Can you talk more about that? Because I had a question. Like, can you help us figure out how we would do something like that? Because I think I'm a subscriber, but I don't post anything.
Yeah, I'm probably not the best. Our public information folks do that, but I did, and before submitting our comments, had them sort of show me how it works a little bit. So just very, very briefly, but you can. I don't believe it was zip code. I think if you go into county level, you can go by county, and then really you can go into neighborhoods. I don't know that the commission would have to go to that level of detail, but it's just, again, allows targeting. We do tend to get a lot of feedback. Sometimes that snowballs into things where we need to turn off comments and things like that. They tend to take on a life of their own, as I'm told. But
you post on behalf of your agency.
Yes.
Okay.
Yes.
Okay.
Just briefly on other parties' comments, I do agree with Duke that maybe somehow getting all the dates into one document would be appropriate. I don't know if that's the public hearing notices or the notices of filing. I think there's certain dates that can go in there, and then others that would have to be decided after those notices go out. But yeah, having one document would be helpful. Also agree with Dominion that if the customer prefers an electronic notice, I have no problem with them receiving these public hearing notices electronically. The public hearing scheduling, one comment that we had was whether it's possible, and again, this is probably a logistic technical issue, but whether it would be possible to have virtual and phone options at the same time as a live hearing. I know that.
So we can?
Okay.
We've done that in some. So what you're saying is if a customer does not have access or doesn't want to use WebEx, they can just call, or we call them. I didn't mean to interrupt you, but I'm trying to follow.
However it would work for the commission, it was just whether, and again, I think there's a lot of considerations here. We just wanted to raise it that if you have a live hearing scheduled, I mean, you're right, there's limited dates for customers to participate. There would be January 5th in Beaufort, or January 7th in a certain date. So maybe they can't get there live then. And I think the commission has pretty consistently recently at least held a virtual phone option. The commission's here in Columbia, and it doesn't matter where you're located in the service territory, right? You can participate. We just wondered whether having that phone virtual option at the same time as the live hearing would be more. So you call somebody, they might be present in the hearing room.
Okay.
The next person might be on the phone. And again, a lot of considerations there, but to this idea of canceling public hearings if no one shows up. I mean, if no one pre-registers, right? So I think the commission, every notice does say pre-registration is required. Now the department, we're all for having, consumers having the ability to comment and participate this in as many ways as possible. Don't want to take that away. Also balancing this idea that, right, there's a lot of resources spent. There's a lot of time from not just the commission, all the parties, travel involved, all those things. We don't have a position on it, but I thought potentially with that idea, if you had a virtual phone option also, then that could still be open if the commission says, look, no one pre-registered.
Okay.
We're going to cancel the live hearing, but the phone option and virtual option is still available. Again,
on the same day.
On the same day. Again, a lot of logistical considerations there. I don't know that it's a perfect.
So I think what you're saying,
compromise,
Roger, is the deadline to pre-register would have to be earlier, I think, based on what you're saying. So that the commission could.
I think it's early. It's at least several days before time now, isn't it? I didn't
It
pull up
is,
any
but
examples.
I'm still a little concerned. Not saying that it can't work. I'm concerned about customers getting the word that that it's been canceled.
I agree. No, and again, like I said, the department is all about having as many options for customers to participate and provide feedback. Just trying to offer some constructive comments if
That's fine.
Considering other options.
No, I'm not trying to cut you out. I'm trying to follow what you initially thought about. That's it. That's all I'm trying to do. So it sounds like it. Tell me if I'm wrong. If there aren't any pre-registrants, X number of days before the customer public hearing in a community, then the commission could consider canceling that event in the community. Let's say it's in Jasper County. Okay. So they canceled that public hearing in person, but they still provide the ability for customers to call, for us to call the customer. Well, see, then there wouldn't be any, I don't know who we would call. Because there are no registrants.
Yeah, certainly understand it. I mean,
No.
I know in the past the commission has also said pre-registration is required, but that has allowed customers
Yes.
that register at the time of the hearing. So I agree. I mean, it could be difficult whether it's you open a phone line for a certain amount of time. Again, logistics.
We'd have to work through
I
that.
haven't thought through all the logistics.
But we appreciate it though. Seriously, that what you're saying. We're gonna have to think through how we would do that.
Now, again, thinking through it here on the fly, which can be dangerous, I guess. But if you've had let's say you did go a virtual live, virtual, and telephone options are all available.
Okay.
And pre-registration was still required, and no one pre-registered for the live hearing, but people did pre-register for phone or virtual. You would know that ahead of time.
Now that I can see that. Are you going to appear in person, or would you like to appear virtually? Right. I see. And so if there aren't any registrants who are going to appear in person, that's easier to cancel that hearing, and then the commission can just have a virtual hearing. I understand.
That was the thought behind it.
Okay. Sorry, I badgered you. I just was trying to understand.
Okay.
Just trying to. Okay,
That's
I'm with
okay.
you.
Let's see. Just see if we had any other responsive comments to anybody there.
I like that actually. Sorry, it just clicked for me. A deadline for like live, and then a deadline for virtual. That makes sense. Like deadline to register if you're going to appear live, and then a deadline to register if you're going to appear virtual. I'm sorry, it just clicked.
Yeah, sure, it could work.
Okay.
So let's see. Next one I was going to comment on was the pre-hearing briefs, and really I think this is one of the more important ones as far as getting into the substance of hearings and commission's decisions. As we said in our comments, I think they should really be very limited circumstances, as they have been in the past. Unique or extraordinary complex issues or procedural issues. I think most other parties agreed. As we said in our comments, when these are pre-hearing briefs, you run the risk of these issues being based on something other than testimony or evidence. As much as we're all professionals and attorneys and understand laws, it's can get into other issues that may or may not persuade or influence the commission. Let's put it that way. So again, I just think they should be limited. Fine with if people want to request them, and then parties could agree, disagree. But as others have said, right, you're going to get into a brief, a reply brief, a response brief. That's just going to add time again with a rate case in 6 months. That's just unnecessary most of the time, I think. So moving on to DMS, again, echoing everybody else, great job. We did suggest maybe to the extent possible, getting the older case documents as much as possible. I don't know if there's a deadline or a cutoff right now. 2002, nothing's on there. And again, there's technology limitations there as well, but that was one of our comments. The PSC consultant selection process, as far as we've seen, is fine. Just recommend as early as possible. There's a limited number of experts out there, particularly those that may not have conflicts that can assist the commission. So just suggest that as early as possible. And then my last set of comments were on the live streams. That's been said already. Finding a way to make finding old ones easier. One thing that we thought about, I believe was in our comments, was whether there was the search function or something that was a direct link in DMS. So in DMS, I believe, if I recall, it links you to the ETV site, but not directly to the docket. I don't know if that changes anything from your cost perspectives with the search function, but that's maybe another option.
So we talked about that issue. Let's find an old docket. Let's see. I would have to use probably 2023. And let's find a docket. We spoke about that issue yesterday. Joe, I'm gonna be quick, okay? Just give me 1 second here.
While you're doing that, I'll just go ahead and get in my last comment. As we
Sure.
agree with others that the live streaming ex parte briefings would be allowable. And we would,
Oh,
we
make
would like
them
to have
live
that option
stream
at
them?
times. Yes, ma'am.
Okay, Mr. Mustin, you hear that one too? Okay. Okay, I'll be quick. I promise. Let me find this. Let's see. I want to find one, Mr. Mustin, with a hearing, and not look like I'm picking on somebody. Oh, here's one. It's pretty benign because everybody participated. So this one is 2023-369. It deals with whether or not to conduct the independent study regarding the integration of renewable energy. So then here's the hearing, right? This is the link that you're talking about, and we discussed that yesterday. We tried to make Randy work miracles. We said, Randy, what about on the back end, on the front office? We said, what about putting a comma after that and then placing another link? And when we did that, all it did was create one link. We were trying to also make sure we didn't have to spend any more costs. So, long story short, Randy Erskine, our IT manager, is going to ask Spartan for a quote to add the ability to add additional URLs. Why do I say that? Because if you look now on the live stream, you'll see where Ms. Purvis, for convenience of the viewer, will create parts of videos, of archived videos, so that it's easier for the user. Let's see if I can find one. She'll create like a part 1 and a part 2.
Oh, okay.
Okay, and that's why we need the ability to. I'm just gonna seem like I'm picking on Duke, but I'm not. That hearing, I was like September of 23, and I remember that because, like I said, I was looking for the link yesterday. But here's another example. This is an ND, which is even better. See that part? There's a part 1 right here, basically, part 2, part 3. So we need the ability to add more than one link to Mr. Hall, to the DMS page right here. You're right. Up to the date of the hearing, this link, and until the hearing concludes, really, this link will always send you to the page where you can watch the hearing live. Once the hearing is completed, then we would, if we had the ability, we could go in and add the link to the docket. We do want to do that. Am I right, team? All right. But we have to spend a little bit more money. I wouldn't think that would cost much because it appears that the code is already there and he would just need to duplicate the code. I'm not a programmer. I don't know, but that's what I think would happen, Randy. But we don't have the ability to do that right now, include more than one URL. We are working on that.
Sure. Well, I mean, if the search function is cheaper and easier to implement, I mean, that's fine. It's just we're throwing out ideas.
I think Mr.
easier
Terrain,
ways to find the.
I think he would like, though, if we could just place it under the docket because we have no control over YouTube. And I can't change the way YouTube searches, but we have more control over this product. Okay, one more thing, everybody, before you go take a break. Let me show Mr. Burns what I have here. Ms. Purvis, would you show this to Mr. Burns? Mr. Burns, can you see that? Is Mrs. Burns still there? Okay, great.
I can hear. Yes, I can see it.
Okay. So on your break.
Sorry, my son had just called me. He caught me at the end of talking to my son on the phone.
Okay, no problem. These are some dates I just want you all to consider. And then also, we're not done yet, of course. This Act 41 discussion, I just need your feedback a little bit so I can tell the chair, if that makes sense. So let me give this document to you, and then we'll go on break.
Okay. So, may I clarify, we're on break now until when? I'm sorry.
Okay, I'm back, Ms. Burns. I was distributing those documents.
Oh,
Is
you're
ten-
just passing the document. Sorry, I
this-
thought you were on break.
Oh no, sir. Does do you all need longer than 10 minutes? Okay. May we come back at 11:16, please? Thank you. Okay, everyone, we're going to continue. Mr. Burns, are you there?
I am, yes, ma'am.
Okay, great. I'm going to, before I get to you, Mr. Richardson, do you have any comments?
No further comments at this time. Again, Piedmont just appreciates the opportunity to be here and the hard work that you and your staff have done to bring this all together.
Okay.
We'll echo the comments about the DMS. It's a great system. And then with respect to the video, and this might just be user errors, I'm finding even at my age, I'm not as technically advanced as even my kids are.
Mm-hmm.
But it seems with the share function on the video, you used to be able to share. Okay, so you guys are aware of that, right?
So yes, it is not working right now. Firefox, if you're able to use Firefox, you can share the video, okay? But it's not working right now on Chrome or Edge. Okay. Yes, but thank you. And ETV's been alerted, haven't they? That the share button is not working right now on Chrome or Edge.
Okay.
Microsoft Edge. But thank you for that.
Well, again, thank you for the opportunity to be here, and the company appreciates all the work the commission does.
Oh, thank you. Mr. Burns?
Yes, ma'am.
Do you have any comments?
CCBA doesn't have a lot of comments on this. I tend to agree with a lot of what has already been discussed by other council, and I reviewed the submission, particularly by Duke, and I thought their statements in their submission were pretty reasonable. We obviously don't have a dog in the fight on the public hearings and challenges by individual customers, so we will stay out of those discussions. I did want to say that as an out-of-state attorney, I greatly appreciate the South Carolina PSC continuing to allow remote participation after COVID. It's very helpful, very convenient, and I really appreciate how you do it. So put in our 2 cents for continuing those efforts, because I think they're extremely valuable. I agree with those who say that the changes in the recent act that was passed by the South Carolina legislature, we really need some more time to kind of digest how that's going to affect schedules. I need to talk with my members as to what positions we would take on those issues. So I think that's an issue for another time, and agree with those that have said that. But other than that, CCBA appreciates the comments by others and tends to agree. I think we will have some comments on the order of testimony and how it affects the discovery schedule, but I think that is probably something for another day.
Thank you. Thank you, Mr. Burns.
Yes, ma'am.
Okay. So before,
I'm sorry, I hate to interrupt. I have an appointment.
Okay.
Afternoon. I had anticipated that we would be done, but to the extent we keep going, do you have an estimate of how much longer we have to go?
So I was just going to
be here if you need me.
Yes, sir. I was going to go one more round to ask if there are any other comments, or I can hold off on that. I do have a question for everyone regarding the customer complaint process. I received an inquiry internally, an employee of the commission, that I need to ask you all about your thoughts. And then, Mr. Burns, we're just going to go over the document that we displayed regarding some potential future dates.
Mm-hmm.
So
I have no objection to those dates, and CCBA doesn't really have a dog in the fight on the customer complaint. So if I disappear, I hope you will I'll beg your pardon if I do that.
Listen, no problem. Thank you for participating today, too, whenever you need to.
Oh, glad to be here, and thanks for the helpful comments from everyone else.
Okay. Okay, so Ms. Edwards has she has another assignment. She had an assignment, so she's not with us right now, everyone. So I'm going to move Mr. Rainey. Do you have any other comments at this time?
Reluctantly.
Okay.
just one. This procedural forum, I guess I'm all in favor of it, and it's fine. My concern is that these matters are going to be decided on a case-by-case basis before the commission can make a decision with everybody involved.
Are
In
you
other
talking?
words, yeah, Act 41.
Did you mean like the status conference checklist? Is that
No,
what?
ma'am.
Okay.
I meant all the changes that are brought about by Act 41.
Oh, I'll need to go back. I wanted you all's feedback on, what type of forum you would like to see the commission schedule, so I can talk to the chair about that.
Okay.
So
Well, I'll hold my comments.
Okay.
then. I'm sorry.
Okay, no problem. Mr. Anselmo?
Yes. I need to clarify one thing in my letter, and Ben raised it on the customer complaint side.
Okay.
I realized by how I ordered my letter on the proposed schedule, I put the notice of the hearing at the bottom, and it's a clunky sentence that seems, I can see the reading that it says, send the notice 2 weeks after briefing.
Yeah.
I anticipated keeping the original notices that go out at the outset of the case.
Okay.
All I asked is that the hearing be set 2 weeks at a minimum after the close of the briefing deadline. Yeah, I'm not trying to reorder
deadline.
that. Yeah.
See, and I thought you meant at the close of the briefing.
Yeah, I did. So the initial schedule that would come out would have all the deadlines that I have in my letter, and then the last thing would be hearing date to whatever the date is. I'll make one up, September 20th, 2025, and that would all go out at the outset of the case. I'm not trying to reorder any notices. I'm just reordering when the hearing. We need a buffer between testimony and the hearing.
Okay, but briefing there, you meant like a
And that should be testimony.
Testimony. Okay, that's what I thought, and that's what. Okay.
And then one last point. Just I think I heard a few statements today that we need to copy DCA and all the other statutory parties.
No,
DCA is not a statutory party
Sure.
to cases until they have to intervene.
Right.
They get notice in certain dockets, but just a reminder, and that'll be further discussed. Roger and I were talking during the break about the procedural schedule, right?
Yes, sir.
And the
We at the commission, unless the department has asked us not to copy them, we copy them on everything anyway. So that's just what we do. But you're correct. Yes, sir.
That's
Mr.
all I
Hall?
have.
Oh, I'm sorry. I mean, Mr. Hall. Mr. Mushton, you're next. Do you have anything right now?
No, I think just from the dates. I mean, the dates are fine. I think I'm not quite sure what it is the commission's going to be looking for. I mean, I think we've had some pretty robust discussions today.
Okay.
We've responded back to as things have come up. I think generally speaking, we're kind of on the same page as to a lot of things. So
Okay.
I guess I don't exactly know what the commission wants as far as follow-up comments.
Well, that's me, because there were some stakeholders who said they would like to provide comments after today's forum. So I didn't know what the substance of their comments could be, and so if we needed to have another forum, that's what that was going to be about.
Okay, got it.
Mr. Wellborn.
Thank you, ma'am. I don't have anything further.
Nothing right now.
Like Mr. Mushin, look forward to hearing what the vision is for the follow-up discussion. But
okay.
And then I guess too, are we speaking to this yet? Or?
Not just yet.
Nothing further than on the substance of today's conversation.
Okay. Mr. Hall, nothing, and Mr. Richardson, nothing right now. And Mr. Burns said he may need to leave, but I think he didn't have anything else right now. Okay, so
I'm here.
Okay. Did you have anything else you wanted to add at this time, Mr. Burns?
No, ma'am. No further comments from CCBA. Thank you.
No problem. Okay, so then, so everybody, I wanted to get your feedback on our current individual complaint process and other than, for example, the comments made about the time frame to schedule testimony, for example, that was provided by Dominion Energy South Carolina. Do you know of any other parts of the individual complaint process where you would recommend changes? Mr. Anselmo, were you going to say something, or you were thinking?
Do you mean procedurally or substantive? Because I don't want to keep us here till
procedurally.
3:30.
But I mean, if you have something else that you want to add, I was thinking procedurally.
Procedurally, no. I will note that it is often difficult to get participation from the pro se litigants on status conferences,
Mm-hmm.
and perhaps some seem more responsive to email and allow receipt of service and notices. So it might be recommended to give it a first whirl through the email process,
Okay.
And then if that fails, have a oral status conference. But that's really just to streamline the process.
Okay.
And take a load off y'all. But that's really the only thing I think. Otherwise, we've covered our procedural side of things.
Okay. All right. So consider virtual status conferences when we need to initially. Does anyone else have anything else?
Just a quick question,
Yes, sir.
Jocelyn. Whether there's a true need to redact the email address of the complainant, since they're a party and a litigant, in a public proceeding. It's just a sort of, logistical thing.
Okay.
But wanted to at least pose the question.
All right. Do we have to redact the email address? We'll check on that.
I agree with that.
It sort of, in our view, ceases to be customer information when they're, it's really the contact information for the party in the docket. Not a huge issue, but something to flag.
Okay. Thank you for that. Okay. So, all right. Here's basically the question I have for you. Would it be so that perhaps in some instances, the process or the complainant being aware that a hearing is being scheduled, excuse me, that requires the complainant's attendance, would it be helpful for documentation in addition to what's provided in the instructions to the individual complaint form? If separate documentation is mailed to the individual complainant, basically stating that the complainant's participation in person or virtually, but we must see their image, is required, and that we receive a written commitment from the individual complainant that he or she will participate in the complaint hearing. So 2 parts. 1, additional documentation provided to the complainant stating your attendance will be required at a hearing if the hearing is moves forward. And then secondly, a commitment from the complainant that the complainant will attend the hearing. Any thoughts?
Yeah, well, we've had recent experience with this, as you know, for several complaints where the customer doesn't show up. I think that would be beneficial, provided that is there will be a subsequent dismissal as a result of the failure to show. I think the complicating factor, in fairness to the customer, is what happens when they submit the right before the hearing request for an extension, right? And if those, as they would be usually for everybody, are routinely granted, kind of ameliorates the purpose of requiring making the certification. But if there is some teeth to the fact that they have certified attendance and don't show, and if they file that motion too late, then the case is dismissed. I think that's ultimately beneficial to everybody.
Okay. I just want to make sure that I've covered. Okay. Ms. McMullen, can I get you to do something for me? Okay, now we will move on back to the schedule. Okay, sorry about that. Thank you for letting me do that. We'll move back to the schedule. This schedule, everybody. And I'll start then. Let's start, Mr. Mushin, because I know references have been made to Act 41. Do you want to file comments? Does everybody want to file comments about how you would like to see that discussion scheduled? Would you rather file written comments on that? Because I don't know if you would prefer the commissioners be seated up there while you make your presentations about Act 41 and we schedule a forum for them. I don't know if you've thought that far. And if so, when?
I personally have not thought that far through.
Okay.
And a question, I'd like to ask them. I think that answer depends largely on what the intent of the commission is. That are we trying to solve for answers to the various positions, or is it just we're offering feedback, commission, do with it what you will, right? If it's a decisional type process, I think we'd all have a different approach to how we'd like to handle it. But if it's just an informal forum like this, again, different answer.
Different, Mr. Terrain.
I think we got to deal with it. The commission is going to have to deal with it one way or the other, and I'm going to just defer to them on what they do, but the sooner the better. I mean, there's some questions in here. Let's just put them out there. Is ORS covered by the discovery provisions of Act 41 or not? Because they're doing discovery under a separate statute. What do we mean by a phase of discovery? I think there's a lot in here, and the responsive testimony, pre-filed, or are you responding to things in the hearing? And if you're responding to things in the hearing, are we still going to prohibit counsel from talking to a witness who has taken the stand and is still on the stand because they may be called as a responsive witness? In circuit court, that's exactly what you would do. You turn to your witness and say, hey, Joe, what's going on? Do you think you can answer this? And then you'd put him up. But if we're prohibited from talking to our own witnesses, it's going to be crazy time. So I think this has got to be dealt with. And my concern is I don't want it dealt with when I don't have a seat at the table. And that act took effect
in May 12th.
May 12th.
Right.
So whoever gets here first is going to make decisions on these things. And everybody else is going to be watching on the live stream trying to figure out how it's going to affect them. So I think we're going to have this maybe uncomfortable discussion pretty soon. And I'll leave it to the commission how to do it. Do I need a rulemaking? I don't know.
Okay, thank you. Okay, I'm gonna have to talk to the chair, and I'll make it a priority. I think I can get to him on Monday. I'll just make that, see how they want to handle Act 41, everybody. What do you think about this other schedule for, I have it displayed for Mr. Byrne. For, let's say, if anyone wants to file additional comments after today, like Ms. Edwards will probably want to file, maybe you, Ms. Richardson, I don't know, when she talked to your client. What do you think about the deadline of July 18th to file those comments? Maybe. And then if you want to participate on July 25th, we'll be here. We'll schedule another one just to follow up if someone has some additional oral comments you want to make. If you don't show, we won't be offended. Yes, sir.
Could I ask for a little more time between the comments being filed on the 18th and the follow-up forum?
Sure.
Maybe like 2 weeks.
2 weeks later. Okay, sure. So that. 2 weeks later.
August 1st is the date that I have.
Okay, great.
Thank you.
Okay, perfect. And then I just wanted to also, y'all, because of all the changes, already consider a date next year. Because a lot of these processes, I think, may be put into place. And so if there's some more refining that we need to do, I'm just asking you to say that date for next year. Does anybody have a problem with that? If you want to attend, you can attend. But
I'm sorry, are we moving the comment deadline?
no, sir. The comment, the forum deadline, yes, sir, is moved to August 1st.
Okay, thank you.
Yes. And then we just ask you to save that 2026 date because I think I think just continual refinement. I doubt we'll be able to, I don't know. I mean, let's say the videos, we've implemented the ability to add more than one URL, and then you have some more recommendations regarding that in a docket. That's the type of feedback we'd be looking for. And anything else that has arisen since the forum this year. That's what we would be looking at. Okay? All right. Does anybody have anything else that you want to add today? Well, we very much appreciate your participation, everybody. Seriously. Thank you for and we know it takes time, but just thank you for your written comments. Thank you for your willingness to sit through this and provide us feedback. And if you can participate on the 1st, we look forward to seeing you on August 1st. And if you have comments that you'd like to file that you didn't file today, but you want to, or you thought about something, please, if you would, file those in the non-docket. Okay? All right. Have a good afternoon. Thank you.